Okay. Welcome to the Family Operating Trust webinar. Today we're going to talk about a very powerful tool that could be used for your families, whether it's monogamy or polygyny. It could be used as a financial tool to build wealth and a host of other things. It is something that has been kept hidden from us for a very long time, and it's still kind of hidden from us, as me and my brother was talking about before we started. When you think about starting your family or have a already existing family, you must begin to think about what kind of financial model you will use to generate wealth and preserve the wealth and also protect the wealth. So here it is. We have what we call the family operating trust. There are many different types of trusts, but we're going to focus specifically on what's called an operating trust. It is a private express trust under common law. Now, what that suggests is that there is no registration that has to occur for this particular trust to exist. It does not have to be registered in the public. You don't have to go down to the county recorder's office or the Secretary of State to register it. It is of your own right authority, sui juris, meaning you have your own right and authority that you're operating within to contract with another man or another woman. So basically, what is a trust? A trust is a contract or an entity. This contract or entity, it is either implied or expressed. There are some implied contracts, like when you ride down the street in your car or motor vehicle, you're operating under an implied contract. It implies that you're going to follow the rules of the road, that you're going to do everything that is necessary to that governs operating a motor vehicle or car. Also, contracts are expressed. What I mean by express is expressed in the form of writing. So when you have a trust, you have an express form of contract. It is further reported that in 1805 BC, the first recorded trust in history was made by an Egyptian named Uha, or U-A-H, during the reign of Amenemher the third. I read that somewhere in a particular book. I have to do some further research on that, but I know that trust, we started, this whole concept of trust or whatnot. Black's Law Dictionary defines a trust as a right of property held by one party for the benefit of another. All right? Simply put, we're going to put it in very simple terms. In its simplest form, a trust is created when you ask someone to watch your package until your child arrives to pick it up while you step away for a moment. The original package owner, the creator or settler, is naming a manager, a trustee, to manage for the child, the beneficiary. This temporary trust will be fulfilled when the package was delivered to the child or returned to the original trustee. So in a trust structure, I want you to, if you have your pen and pad handy, write this triangle, what I call the trust triangle. I want you to write it down because it is key. Because these four essential things must exist for a trust to exist. And we're going to, simplify even more once we get to our diagram. But there must be a grantor, a trustee, and at least one or more beneficiaries. If there is no grantor, trustee, or beneficiary, as well as what's called the res corpus or assets held in trust, then there is no trust. So you must have these four components: the grantor, the trustee, the beneficiaries, and there must be something of substance to be held in the trust. Now, I'll remind you once again, this is merely a contract. It is a contract entity between the parties, or an agreement between the parties. The trust can be statutory or non-statutory, meaning, again, statutory is those type of trusts that are governed by statutes and codes of the state. So when you talk to an attorney or anything like that, they are most familiar with statutory trusts. They don't want to talk about the non-statutory trusts because a lot of them are not trained in common law or non-statutory trust, and they don't make no money off of it. And they only usually versed in one form or two forms of law. So moving right along, the legal requirements of contracts is offer and acceptance between the grantor and the trustee. So someone comes along as the grantor. In the case of what we're talking about in marriage or polygyny and monogamy, someone must be the grantor, meaning someone must start this trust with some substance, some asset, be it tangible or intangible asset. We're going to talk about some of that later on in the webinar. It must be done in the form of writing, a declaration of trust agreement. So this is a document that is created. This document called a declaration of trust is your law. You basically get to create your own law, your own constitution for your own mini government, which is your family, be it monogamy or polygyny. There must be a meeting of the minds between the one who initiates it and the one who is entrusted with the management thereof. Also, these parties must be competent parties. We cannot, as a people, always think that we're going to find the most simplistic methodology when it comes to financing. When it comes to finances and financial structures and wealth building structures, you're going to have to become competent in certain areas of accounting. There are basic areas of accounting like keeping ledgers and things like that, because if you are a husband and you have multiple wives, you want to have some checks and balances. You want to operate a business together. The problem we have is we start businesses and we never structure them properly. We start LLCs and different things like that, but we don't know about capital interest ledgers or seal, operating agreements, and things of that nature. So we have to become very competent, and I'll provide some information to help you become more competent when it comes to trust. For those who are attending this webinar today, you will be giving some gifts, some gifts in the form of ebooks. I will provide for you a book called Living Trust. Also, trust structures. Let's see what trust structures look like. I will also provide for you some Black Law dictionaries, at least 2 Black Law dictionaries, the 1st edition, or the 4th edition, and the 9th edition. So you will get those. Hold on one moment. All right. Also, there must be a lawful purpose for this trust. And I think the post that inspired was a sister, Oju, I believe is her name, in the group, in the polygyny group. There must be a lawful purpose, and for this purpose was mentioned business. For structuring a business, and I think she's in the chat box and she can correct me if I'm wrong, but structuring a business within your family construct to create incentives and some sort of checks and balances. This trust is a perfect model for that, a very perfect model, and you'll see what I mean as we go on. Also for consideration, like we just talked about, some kind of incentive and accomplishing something that is possible. You may have in your family construct the thought that we're going to operate real estate. We're going to invest in tax liens. All this should be things that is well thought out and structured. All right? So moving right along. So what does one use a trust for? Trusts are primarily for four purposes. The protection of assets. So if you have assets, you have cars, and you have property or land, or say you might have some intangibles. You might have stocks, bonds, certain, gold and silver, but those are tangible assets. But any assets, be them tangible or intangible, could be used in this trust model, meaning that the Rockefeller said, own nothing, control everything. Guess what they were talking about? They were talking about trust. They were talking about this entity where you step out of ownership. We always thought, I want to own something. I want to own some land. I want to own a house. I want to own this. Well, guess what? When you own it in your name, then you have a liability. Then it's like dangling fruit that's hanging out there for creditors that think you owe them something, will come after you and seize your asset. Well, with the trust, what happens is you use the trust to own the property, to own the asset, to own the cash flow coming in. Well, the cash flow is coming into the trust as opposed to coming to you. Also, it will help you lower your tax liability. Also, generational preservation of assets. So what that means is when you die or something happens to you, God forbid, but if you train your children properly in trust management, then what happens, the trust just goes on. The wealth is preserved. It doesn't have to go through probate. So one of the uses of the trust, it helps you avoid probate, which a lot of people don't even think about until after. Say, grandma, I knew a brother who he had a car that his grandmother owned and a house. He was taking care of her, but everything was in her name. But they never put a trust in place or never put any kind of mechanism in place to protect the assets. So when she died, he lost it all. Even though he helped maintain it, he helped keep the upkeep of the house, he didn't understand any financial tools that he could have used to preserve and protect that wealth. I see a question. You're talking about this. Would this model work for people who may only want to include furniture and clothes? Absolutely. You can protect your furniture and your clothes as well. What you can do is you could create some unique serial numbers for if they don't already have them. And you create tags, and you put the tags on the furniture and you put the tags on the clothes. And then you can place them in the trust. You can create a document that shows what the trust owns. And the trust could literally put a lien or levy against these assets and record it in the public, stipulating that if anyone comes against and tries to take these assets, they will incur a liability. Also, a car could be transferred or exchanged into a trust. We're going to talk about what some of those exchanges look like. And I'm going to share something with you. This is how white people avoid foreclosure. What they do, they set up multiple trusts, and they create obligations between those trusts. Like, for instance, say you had a trust for consulting, and you had another trust that was used to hold the assets. But say the trust that's used to hold the assets was owed money to the consulting or the marketing trust, but it never paid it. But as surety for the debt, the other trust could put a lien or levy against the assets of the holding trust that's holding the real estate. And if it puts the right kind of lien or levy on it, guess what? It will supersede and have priority over the mortgage lien or whatnot. Kind of like a mechanic's lien. A mechanic liens have priority over a mortgage lien. So when you understand the hierarchy of liens and levies, the highest lien or levy you can get on an asset is either an agricultural lien or a commercial lien. After the agricultural lien or the commercial lien, you have what's called a tax lien. After the tax lien, you have a mechanic's lien. At the mechanics lien, you have a mortgage lien. So a mortgage lien is very low on the totem pole. So if you have any of those pre-existing liens and levies in place, this could protect your family's asset if you have a mortgage. So what will happen is, as soon as the mortgage, they try to foreclose, guess what? They got to pay off those liens first. So this is a way that whites protect their assets. So we have another question. Wow, I have so many family members who could have saved homes. Absolutely. And it's very, very simplistic to do. So we're going to move further before we go into our question. We're going to move into our diagram. I don't know if you all can put the diagram over this. Let me know if everyone can see the diagram. Looks like a flow chart that I have on the screen. And if you want me to repeat anything, you can just speak up and say, hey, either in the chat box or verbally, for me to repeat anything that I may have went over too fast. All right. Okay,
hello?
I'm trying to. Yes, yes.
Okay, can you hear
How you
me?
doing? Oh yeah, we
sure.
can.
I'm good. Could you make the flow chart just a little bit bigger? I can't see the writing inside the boxes.
Okay. All right. We'll zoom in.
Yeah, I can see it. I can see it now. I couldn't read
better
it
now?
before. That's good.
Okay,
That's
wonderful.
great.
Okay, wonderful. Okay, so what we have here is what I call the private family operating trust. Now, you can choose to name it whatever you name it. So I want everyone to understand that you are the author of this. As long as certain things are in place, certain things that must be in place, like these elements that I spoke of earlier, you can call it what you want. You can give it your own unique name. All right. But for our intent and purposes, we'll call it the private family operating trust. Okay? And first, there must be a grantor in this private family operating trust. And I put some little notes here. Oh yeah, yes, ma'am. You will definitely. I'm recording the video, so you'll get the video along with books and everything. So there must be a grantor with an individual or an entity. An entity could be the grantor. The grantor is the one who starts the trust, okay? Who conveys or transfers ownership of property. This is done for the benefit of someone else, beneficiary. In this context, you may have someone like myself or anybody else on this call may be the grantor to get it started. They can start the trust with, say, a few ounces of silver. You can say 3 to 10 ounces of silver, which is going for like about $21 an ounce to get the trust started, okay? So once the trust is started, a name for the asset that is used in commerce is called res or corpus. For those who can see that in the center, it's called res or corpus. Those are the assets held in trust. It could be property that is tangible or intangible. Here's some of the tangibles, which is real estate, land, money, gold, silver, etc. I recommend that if you're going to use some of these tangibles, you can use postal money orders. A lot of people don't know postal money orders are still backed by gold. Fiat currency is what is called green dollar bills today is not backed up by anything. But these tangible assets will help you as a hedge against inflation in this economy, or any intangible equity from other investments, copyrights, and even intellectual property to be held in a trust. You can create what's called an intellectual property trust. It's kind of like your own private copyright or your own private patent, and put a public notice out there that if anyone comes against or uses this, they could incur a liability. All right? So I hopefully everyone is clear on what the res or corpus is and what a grantor is. All right? So what is the trustee? let's say in this, and what we're trying to do with building our families and empowering our families, the husband will be named in the trust document as the trustee. Now, the trustee is an individual or corporation or trust name. It could be a trust. The trustee could be another entity. Guess what? An LLC could be a trustee. So there's so many creative ways you can do this. Who sets aside property to be used for the benefit of another one. So this trustee, he goes out, he takes the property held in trust and invests it, or he leverages it to grow it. His whole purpose is to grow the trust. And say the wives are named as beneficiaries, or the wives, say each wife may have her own LLC or her own separate contract trust, and her trust is named as the beneficiary. All right, that's a possibility. Or, let's see, there's another model that I have here. But before I go to that, let's look at this. What the Declaration of Trust is, a document signed by the trustor or settlor. That is another term for grantor, trustor or settlor. So those terms are interchangeable. So sometimes you'll see on real estate documents, you'll see trustor or settlor, or you'll see grantor. They are the same thing. Creating a trust into which assets are placed. A trustee is appointed to manage the trust, who may be the party who created the trust. The powers and duties of management of the principal and profits of the trust are stated, and distribution of profit and principal is spelled out in the trust document. So that, again, that trust document is your law. So it's easy to create. You can even Google trust declarations of trust, and you'll get sample declarations of trust. All right? Then, of course, you have a beneficiary. So here we go. All right? So say we have a trust established, and we want to create what Sister Oju mentioned about these incentives, things like that. So a wife comes along. After the trust is created, any time someone places something into the trust, they are called an exchanger. So I want you to mark that down. Can everybody see this pretty good? Okay. Yes, okay. So I want everyone to write down exchanger, which is almost like an investor, okay? But in trust language, it is called an exchanger. Here's a distinction I want to make. When you buy something with a green dollar bill, a Federal Reserve note, fiat currency, monopoly money, when you buy something with that, you just created a taxable event. That's why they're able to tax you, because there was no substance for substance. You're using their benefit, a benefit of the democracy. A benefit of the democracy is using this war script called a Federal Reserve note. But when you use real money, like gold and silver, or I give you something and you give me something of substance in return, it is called an exchange as opposed to a purchase. Exchanges are not taxed. If I came and you had a car and I gave you gold and silver for the car, it is an exchange. There's no taxation occurred. If I have a company and I pay my employees in gold or silver, it is not taxed because I've given them substance for their labor. Because Federal Reserve notes are not real. It's just some paper. There's no real substance because it's not backed by anything. So back in the 30s, I believe, when they took the dollar bill off of the standard, the gold and silver standard, that's when it became non-substantive. So when a wife comes along and she wants to put her time or money into the trust Okay, we already. She gets what's called a trust certificate. We call them TCUs. Okay, hold on. I'm going to show you an example of what one of the trust certificates look like. Give me one moment. Let's see. Where are these certificates? Hold on. Please bear with me while I locate it. Now, these trust certificates, you can make them look how you want them to look. So it's not right or wrong that you get fancy in your design. It just shows what her. It's a way of her showing her what she has vested in, how many units she owns of the property held in the trust. Okay. Now, every time she puts or pledges her time, say she pledges to put in 20 hours a week. That 20 hours a week at the rate of, say, $15 an hour has a value. So you can create a bond that stipulates the time that she's going to put in to the family business. Okay? I'm going to show you this now. There we go. Okay. Here's what a certificate looks like or could look like. All right? It is a certificate of capital interest. It's a sample that I made when I was teaching some of my trust students. This certificate that James Brown is the holder and fiduciary agent of 100 units of capital interest. It should be 100 right here, but it says 21. So it shows how many units that she holds. You get to determine the value of those units. All right? So that's what a capital interest certificate looks like. And this formula that I'm going to show you all will help you understand that a little better. So when this wife puts her pledges or puts her time or money into the situation, into this trust, she also gets to name her beneficiary. Okay? So say she had another company. She gets to name her company as the beneficiary. So when money is made in this trust, the husband is going out, he's investing in tax liens. He's investing in rental property. And this trust is growing on a monthly basis. Okay, well, those profits and proceeds will go to her beneficiary that she named. All right? And those beneficiaries will get what we call UBIs, which is a unit, another certificate. I just made this one a different way. It has the trust seal on it, so all the trusts will have a seal. And this stipulates how many beneficial units that the beneficiaries hold. All right? I don't know if you see that. But again, you can get as graphical or simple with how it looks as you want, right? But this shows her ownership interest. This is some critical information or what we're doing now is banking. This is private banking, brothers and sisters, all right? Just so you know, all banks operate on trust law. The Constitution of the United States is a trust. If you read the first page, it talks about a grantor. So anytime you see this kind of transaction and terminology, you're dealing with private banking. So you're creating your own bank in your family construct, all right? So hopefully everything so far is made. Any questions so far before we go to the next portion? Any questions about this particular layout? So just to recap, are you thinking about your question? The grantor, you must have a grantor, you must have property to hold in trust, there must be a trustee, There can be multiple trustees also, and then there must be a beneficiary, all right? And then later on, after the trust is set up, anyone who comes to put anything in is now considered an exchanger, all right? So anyone can invest in that particular construct. So moving right along, now we're going to get to the, and the incentive could be based on whatever goal is set. So the more work you put in, the more TCUs you can acquire. And these TCUs could equal so many ounces of gold later on, or so much money later on. So that incentive is there to work on behalf of this trust to help it grow, to increase your wealth. So it is set up where you only get in what you put out. That's why these units are set up. Because so this husband, he's not biased, so he don't come in, he can't be biased if this is run properly. He can't just say, oh, I'm just going to give you some units just because. No, this is set up where you only get out what you put in. If you're only holding 21 units, your distribution is only based on 21 units and not just because. So it's kind of also an honor system as well. Okay, I see a question. Can a beneficiary also be an exchanger? Yes, anyone could be an exchanger. They would just do a formal request in the form of writing to exchange something into the trust. And then a meeting could be held, and you keep the minutes, of course, so you want to have a trust book as well. You keep the minutes, and then there could be a vote. You could set up this business construct like there in your trust document. It say that in order for an exchange to occur, there must be a majority vote or a supermajority vote, depending on how many in your family. If you got a family of 4 or a family of 5, a supermajority vote might be 5. Everybody got to unanimously agree. But a majority vote could just be 3 or 4. Does that make sense? Okay, the next question is it easy to create the documentation? Does it have to be official through the court by chance? No, it doesn't. And it is easy to create the document. Like I said, you can Google the trust document, trust indenture. One term you can look up is trust indenture or declaration of trust. And you'll see that in some of the books that I'm going to give you. And you do not have to go through any court system to do it. The documents have to be notarized. No, they don't. You can notarize maybe the front of the document, because you don't want to, if you put your whole document in the public, what happens is now you compromise the privacy of it. But so you can maybe take the first page that stipulates the parties involved. And I'll get more information to you to help you understand that a little better. So I can understand it is a contract, so you might want to take the first page and get it notarized just in case there's any legal things that may occur where there's a dispute. Or you can also hire what's called a trust protector. You could take someone that the family mutually trusts. It's called a trust protector. The trust protector is there to make sure that the trustee is doing what the trustee is supposed to do. So that's some trusts actually have a protector, and that protector can even come to and be the chairperson of some of your meetings when you hold your quarterly meetings or however often you hold your meetings or whatnot. Does that make is everything clear? All right, I want to make sure that. All right, cool. All right. Here's what we have, what's called an allocation ratio. So everyone, if you haven't already, jot this down. An allocation ratio. Okay. This is where it gets a little complex, but I think it's okay. You have what's called here's a ratio I created, the 25 to 75 ratio. So what's on the left side is what the ownership interest of the exchangers. They own 25%. Say these wives or exchangers own 25% of the total res or corpus or assets held in trust. Then you have the 75% is owned by the beneficiaries. Okay? Let's look at this. It is a percentage. The percentage is a quantity expressed in hundreds or a whole. So you have, hold on, before I do that. Say $100,000 comes in to the trust. 100,000 comes in. So 25% ownership interest of that is owned by the exchanges. The other 75% of that is owned by the total beneficiaries. So this ratio is based on the total number of beneficiaries and the total exchangers. All right? But each exchanger has their own amount or percentage of TCUs that they own of the total amount of TCUs that exist. Say you start this trust off with 1,000 TCUs. Let's just say we're going to start with 1,000 TCUs, or let's say 100. So of those 100 TCUs, this exchanger in particular owns 10 of them, which is like 10% of the total. So and then the beneficiaries, just look at this as one beneficiary right here. This beneficiary owns 20 UBIs, units of beneficial interest, of the total units of beneficial interest, right? So when this 100,000 comes in, this particular exchange over here has 10% of that, okay? So what is 10% of that? Let's look at the formula. You take the 10% divided by the 25,000, which is the 25 that goes to the exchanger. All right? So you take the 25 and divide it by the 10% ownership of that particular exchanger, and you get 2.5 thousand. With that. So again, 100%, 100,000 comes in. This exchanger has 10 TCUs, which is 10%. So of that 25 that goes to all of the exchanges, this 25,000 goes to all of the exchanges based on their percentage of TCUs held. So this exchanger gets $2.5 thousand. Does that make sense? Hold on. Mr. Oju said, can a wife be given, say, 10 TCUs upon marriage, even if, yes, she can. Yes, she can. That's a good point. She can be given, as soon as she comes into the marriage, because she is a wife, she's given a minimum amount of TCUs to start with. Because, of course, the husband is responsible for maintaining her. So he gives, well, he just has to set an overall amount of TCUs that he's going to start with. He got 1,000 TCUs or 100 TCUs. And then, so this wife comes in, she gets 10. Another wife comes in, she gets 10. So anything else could be earned on the business side of it. But if she don't do nothing else, she going to get a disbursement for her 10 TCUs that she got. All right? Let's see what else. So say when she named her beneficiaries for the work that she pledges, and maybe even her money that she pledges. and then one of her beneficiaries or her company. Her beneficiary could be a nonprofit. Her beneficiary could be another trust or an LLC. So how does this beneficial units work? Basically the same way. Because of this $100,000 that came in, the total beneficiaries get $75,000. But this beneficiary is only holding 20 UBIs, which represents 20%. So, hold on. So we do the same formula. You take the 20% and divide it by the 75. All right? That's 75K. And they get $15,000. Or her children, right? That's a good one. Her children could be the beneficiaries. All right? So that's the simple formula for finding those percentages and the simple allocation ratio that you can set. Now you can set this allocation ratio how you want. That's something you have to sit down and determine what makes sense. And then the children as beneficiaries, we create some incentives for them. I'm sure they love getting money. I'm sure they love these distributions. And check it out. You get to determine your distribution ratio too. I didn't do a flow chart for distribution ratio, but I'm just going to mention it. Distribution ratio could be every 3 months. A distribution ratio could be every month. It could be every year. It's up to you to determine how often a distribution would occur. Now, I want you to know this. Trust or not taxed. Trust or not taxed when it comes to income, because when money comes into a trust, it sits in the trust. The taxation occurs when the disbursement is made to the beneficiaries. Then the beneficiary pays a tax. Or the trust could loan money to another entity, and loans are not taxed. See, the way to avoid taxation is, some people say, I'm just not going to pay my tax. That's the wrong way to look at it. If you create a taxable event, you must pay a tax, period. If you don't want to pay a tax, stop creating, learn how to stop creating taxable events. Loans are not taxable. Exchanges are not taxable. All right? Check this out. Your trust can own an LLC. Your trust could be the single member of an LLC. Okay? The IRS looks at a single member LLC as a disregarded entity. What do I mean by disregarded entity? Or a pass-through entity. Okay? So when you go do your articles of incorporation with the state, with a particular state, you will put the name of your trust as the member. Okay? So when money comes in to the trust, guess what? It goes to the member. The members are the owners. So in this case, the trust has 100% capital interest in the LLC. So what happens is the money sits in trust until there's a distribution. The taxation does not occur until the beneficiary receives the distribution. But what if the trust didn't make a distribution? What if the trust just took care of the beneficiary as opposed to making a distribution? Guess what? It's not a taxable event. Okay, I got a few questions. What about an LLP, a limited liability partnership? I'm not as familiar with limited liability partnerships. I know what they are, but I've never set up one myself. I have, for privacy purposes, I have set up a New Mexico LLC. New Mexico LLC costs $50. Why a New Mexico LLC? Because it provides protection and privacy. Matter of fact, when you set up a New Mexico LLC, they don't even ask who the members are. So they don't even know who owns it. This is what they call a private company. That New Mexico LLC only asks who the organizer is. And you just have to have a registered agent in the state of New Mexico. And there is a registered agent service that charges $50 a year in the state of New Mexico. Okay, so if the trust owns the LLC, does the trust have to be recorded in the county? No, it doesn't. Even though the trust owns the LLC, it still does not have to be recorded. The LLC has to be recorded because an LLC is a creature of the state. So the LLC has to be recorded with Secretary of State office. But this particular type of trust is considered an operating trust set up to operate in the public or operate a corporation. Now you can layer trust. You can layer trust, and I'm going to show you all what some layered trusts look like. Okay, give me a moment to pull it up. Also, I want to make sure I put some of this stuff in what I'm going to give away to everyone. Trust. Okay. Trust. Oh, trust arrangement. Let's go with trust structure. I'm going to show you how heavily layered this stuff can get. Hopefully everyone can see that. You have what's called the origin trust. Some people call the origin trust or the family trust at the top. And you'll get this document, so don't worry. Some of these are so layered, man, it'll drive you crazy. But that's why I use these mind maps a lot. I like to use these mind maps because it helps me structure things. So you have the John Henry Doe Trust, which is the origin trust that created, say, a master trust. You can create a master trust to be the trustee of all your other trusts. Then you have a holding trust, a central bank and holding trust. And then here you see the one that we're talking about is your operating trust. And as you can see, this operating trust over here to the left, it owns an LLC called Sunray Management LLC. But the master trust is the trustee of the common law enterprise operating trust. All right, and then you can have what's called single asset trust. Like I recommend if you have a house, do not put all your homes in the same trust, because if like somebody slips and falls at that house, that trust is still liable and all its assets is still to be seized. So you don't put the purpose of it. You put each house in its own simple trust so that only that house is at threat and not all of your house. Like if you have a car, you can put that car in another single asset property trust by itself. You want to split them up like that. So I'll give you this document or whatnot, so you can kind of look at it, look how it's broke down, some of the other stuff. I'm gonna show you another one, and then we're gonna move into questions. All right, that's a simple one there. You're gonna have this document too, so you can see kind of what it looks like. Trust arrangements. It gets real complex. Watch. But this is the best. This is what they've been keeping from us. This is how the Rockefellers, the Rothschilds, the Bilderbergs, this is how they build their dynasties. This is how they build their empires. And it's all contract. All the trust is really a contract. it can get complex, but it's not as complex as people make it out to be. So don't be afraid of it. I read in the doc you sent me yesterday about the trust dynasties. Oh yeah? Oh yes, yes, yes. That's what it's all about. Building, if we're going to operate in polygyny and things like that, we need to think about dynasty, building our dynasties, building our empires, you know, for years and years to come. All right? So, with that being said, does anyone have any questions? Feel free to start, put it in the chat box if you don't want to talk. So we'll open the floor up for questions. Anybody? I know y'all got some questions.
You know what? It's a lot of a lot of new terminology. I'm just trying to let it all sink in.
Say that one more time.
It's just a lot of new words that you're throwing at me, so it's taking taking a minute to let it all sink in. But I'm with you. I understand what you're saying.
Okay,
and the
great.
pictures are helping. Yeah.
Great, wonderful. Yeah, these are definitely some new terminologies to get familiar with. But what'll happen is these terms that I'm throwing out there, you're going to start seeing them now in other stuff that you do that you didn't see before because you didn't really think about it. But now that I put it out there, these terms are in a lot of contracts that you sign that you don't know because you may not think about it, but you'll start paying attention to them now.
Yeah, when I started studying a trust, I realized that a bank account is a trust and a life insurance policy is a trust.
Is a trust. That's right. That's right.
So
Absolutely.
could you talk about more about how to transfer mortgage properties to a trust?
Okay. With a mortgage property, you have what's called a due on sale clause in mortgages, right? So if you try to quit claim, that just means that if they think it's being sold or transferred, they're gonna want all their money. Okay, they're gonna want it all. It's called a due on sale clause. However, you can transfer your interest, your ownership interest. Say you've been paying on a mortgage for the last 20 years. Well, how much have you paid into it? Say you paid $30,000 into a $100,000 mortgage. Guess what? You got $30,000 ownership interest or equity in that property. So what you would do is you would create a bond of some sort that stipulates your ownership interest and then exchange that bond into that trust. Okay? Then that trust could put a lien against the house for its ownership interest. The same way what they do. When they give you the house, they so-called give you a loan. And then they put a mortgage lien against the property as surety for the debt that's owed to them. You can, in a way, you can do the same thing. You transfer your ownership interest in the mortgage into the trust, and then the trust turns around and puts a lien against the property as surety for the ownership interest. Does that make sense?
Can you say that one more time?
Okay. Say
Please.
Say you've been paying on a mortgage for the last 20 years, and you've paid $30,000 into the mortgage.
Okay.
You do have some vested interest in this property. So now you can create a bond. You create a bond or a security, some kind of security agreement.
Mm-hmm.
And then you put that security agreement or that bond into the trust. You exchange it into the trust for TCUs. Okay? So now you've given your ownership interest over to the ownership of the trust. So now you control it through the trust. Then the trust turns around and puts a levy or lien against the house. for the ownership interest that you've transferred into it as surety for that, as a surety for its ownership interest.
Now, this type of exchange would have to be recorded in the public, though, right, in order for it to be honored, I would assume?
No, it doesn't have, because you're not doing a quit claim. You're not doing a quit claim deed. If you did a quit claim in the public of that property into the trust, that mortgage company is they're gonna foreclose on you immediately. They're gonna immediately go into a foreclosure process because of the due on sale clause. Now, there is a code in the United States Code that says that if the only way a due on sale clause is prevented if it's transferred into an inter vivos trust, like a living will or a living trust. If it's transferred into a living trust, but I haven't explored that yet. I haven't explored it enough yet. We're looking into, right now, myself and a group that I deal with is looking into how to do that without the due on sale clause, because it is in the U.S. Code that if it's transferred into a inter vivos, what's called an inter vivos trust, also known as a living trust, as long as the original payee or payer on that note still remains the beneficiary, that it can be done. But we haven't done it yet. We're still working on, we're going to try to make them adhere, because if we make them adhere to it, then you can assume loans. You can assume mortgages. You can go around and there's people that have mortgages. You can go in there with the right law and code and assume that mortgage, take over that loan in your name or in the name of your trust. But again, it's something that we're still looking into.
Okay.
So I'll keep you updated on it, and then I'll even share that U.S. code. Hold on, matter of fact, I got it somewhere here in my office. Give me one moment while I find it. Okay, here we go. I'll tell you what that code is. That U.S. code, and you can kind of look into it as well.
Do you consult? Do you do consulting for this?
Oh yeah, absolutely, absolutely. I actually teach classes on. Me and a partner of mine, we teach classes here in St. Louis on trust. We teach a 5 to 6 month course on trust management, trust establishment, and trust management.
Okay.
So when you know anybody on the call that wants to get it done for their family, you can contact me privately, and then we can talk about what that looks like. Okay, here we go. Assuming mortgages. Title 12, I'm going to type it in. Title 12, Chapter 13 of the U.S. Code. Title 12. I'm typing it in also. 13. 1701. Okay. Put it. Title 12, Chapter 13, also 1701 of the U.S. Code. Check it out. It deals with the assuming loan, assuming a loan or whatnot. Let's see.
Okay.
Is that how money was made from the real estate bubble? Yeah. They oh boy, that's a whole nother webinar. Yeah, they did a number on us on that. It's also, if you think about it, this is how we can, using the trust is how you create your own money as well. Because when you think about it, say you you put gold in the trust. Say you came along as an exchanger and you put gold in the trust, or whatever you put in the trust, and you get TCUs. Guess what? Your TCU, you just created money that's backed by gold. You see how it works?
Mm-hmm.
So those TCUs, you can put your face on it, put your family seal, your family crest on it, and now y'all have your own money.
I did want to ask earlier, you said that is it one of the assets you can use in the trust, it can be intellectual property. I was going to ask, can you, would a family crest be something that would be considered intellectual property?
Yes, you can put your family crest into your trust as intellectual property, and also every trust should have a seal. Let me show you a trust seal. You look on the screen, I just put up a sample of trust seal that I created in some of my training. It can look how you want it to look. You can even use your family crest as your seal. And some of your more complex trust structures, you have an executive secretary, you have a general manager, you have an executive secretary, a general manager, and a trustee. When you have a lot of assets that you are managing, so say in a polygynous marriage or arrangement, the wives could be one of them could be the general manager, one of them could be the executive secretary. You know, so you can kind of set that up how you want it, and that could be their work that they put in for the family business is functioning in those capacities. Here's another seal that I created. It don't have to be as fancy as mine. I just happen to be a graphic designer, so I like to put a little extra on it.
Now, does those positions that you just talked about, are those positions for the Board of Trustees, and does every trust have to have a Board of Trustees?
No, every trust does not have to have a Board of Trustees. I only recommend a Board of Trustees if it's a complex trust with a lot of assets.
Okay.
Because you're going to need to have whole meetings on maybe on a quarterly basis. And every trust should have what's called a trust book. It have certain tabs in the book, like one for the minutes, a tab for any contracts and agreements, a tab for a ledger. You should have ledgers, like an asset ledger.
Mm-hmm.
There should be a capital interest ledger for all the TCUs that is there and who are the owners or holders of those TCUs. There should be a capital interest ledger. There should be a beneficial interest ledger.
Yeah.
A debit and credit ledger that shows what goes out versus what comes in. Mm-hmm. So those could be Excel spreadsheets, but those things you want to keep in your trust book because you want to keep, the trust is really about keeping good records.
Right.
And I think that would help. Go ahead.
With non-statutory trusts, I would think it's important, just in case anybody ever challenges it, you have the records to show that, this has been in existence and for how long, right?
Right. That's right. And that's why you follow still, even though it's a private trust, you still follow certain principles of trust because the government and the courts are so slick. That trustee handbook that I shared and that some of you who haven't got it will get it, the guy who wrote it, his name is Carlton Weiss. He used to be a trust attorney, and his job was to unravel trust.
Okay.
And so he switched. When he switched to start teaching about the loopholes and ways to patch up those loopholes. Like, you don't want to set up a trust where you the grantor, you the trustee, and you the beneficiary.
Right.
They won't. That's called a screwball trust, and they will unravel that thing so fast and charge you with all kind of stuff.
You can hold 2 of those positions, but not all 3, right?
Right. You can't hold all 3. And if you're going to be say the grantor and a beneficiary, there must be more than one beneficiary. You just can't be the only one.
Okay.
You know, and you can have more than one trustee as well. But what happens when you have more than one trustee, if there's ever a dispute, you got to get an attorney to represent you in court when there's according to trust law, when there's more than one trustee.
Now, wouldn't a board of trustees be more than one trustee?
No, because they only call the board of trustees, but each one of them are not the trustee. Only one trustee still exists.
Okay, so that's like an owner and a board of directors for a corporation.
Right, kind of similar to that.
Okay.
Then your trust document is kind of like an operating agreement.
Now, will you give us a sample of the trust book?
Sample trust book. What I can do is I'll type the components that make up the trust book.
Okay, good enough.
Otherwise, I would have to send you a physical book.
Yeah, no. Just I just wanted a shell, just to know what goes in it.
Yeah, I'll put that here.
Thank you.
Oh, no problem. No problem at all. Anybody else? I got time, y'all, so far away.
I know I'm going to have some questions later once I start going through this stuff, but right now, you know, this was a very thorough presentation. I thank you for the time and the energy you put into it.
You're welcome. You're welcome.
I know once I start going through the documents and learning more, I know I'm going to have questions, so I'll definitely be in touch.
Okay, cool. Well, I'm going to show some of the things you'll be getting in this. I'm going to send you all like a link to download these other books. If you can see on the screen, in there it's going to be what's called Gilbert's Law Summaries on Trust. Everyone will get a copy of that. You get a copy of this book called Living Trust for Everyone, Why a Will is Not the Way to Avoid Probate, Protect Heirs, or Settle Estate.
Mm-hmm.
Also, you get a book called Powernomics by Paul Anderson. A lot of you may be familiar with that.
I already have it.
Oh, you got, okay, cool. What else? You'll get a book on property law, book on the law governing property. That'll help out a great deal. And then you will get Black's Law Dictionary, fourth edition. That's the fourth edition. And then you'll get Black's Law Dictionary. That's the first one, first edition.
Okay.
It's an old looking thing. Yeah. So, all right. Anybody else?
I'm a part of an organization, a nonprofit organization and society, and I'm going to, talk about this information with them. So we may be calling on you to do the presentation again, but we'll pay you and whatever you ask for it, because this is valuable and it's a perfect way to set it up.
Okay, wonderful. I look forward to it. I try, what I try to do myself personally, everything I do, I try to find a way to put a trust in there some kind of way.
Yeah.
Because you can do private real estate investment groups and use this model of exchange and TCUs and UBIs. It's beautiful.
You know what? I did have a question I wrote down earlier. What is a land trust?
A land trust is a simple trust. You know how in real estate they require seasoning before, sometimes you buy a property for investment purposes, they want it to be seasoned. They want you to hold the property for so long before you can resell it.
Okay.
So what a land trust will do is when you buy it, you set up the land trust, which is a quick document, and then you buy the property with the land trust or put it in the land trust. And so what happens, instead of showing a sale in the public, all you do is change the beneficiary on the trust or the trustee on the trust to the person who you're giving the property to.
Okay. So it's an exchange and not a sale.
So Well, it may not even be considered as change. You just like, it's already in the trust. So all you're doing is changing who the beneficiary or the trustee is to the person who you're giving it to.
Okay.
Then y'all just do so it's more of a private exchange than it is a public exchange or a public transaction. Well, in the public, say if the land trust is recorded, some land trusts are recorded. So if the land trust is recorded, it never shows that it changed. It just shows that it's still owned by that land trust.
Okay.
So would that be a good process? Brother, would that be a good process to use when dealing in tax lien businesses or properties?
Yes, absolutely. Yeah, a lot of people will buy tax liens through a trust. It's better, if you're going to buy a piece of real estate and you're going to own it flat out, it's better to buy it through the trust anyway for that purpose.
Mm-hmm. Okay.
Yeah.
So in the case if you had, say you own communal property, say you had some communal land, you and members of your community purchased, and you set up a land trust, would that be used to transfer ownership from one generation to the next?
Oh, absolutely. Absolutely. You just would train the children as they grow up to be trustees. Teach them, like out of Carlton White's trustee handbook, you teaching them how to manage the trust, how to hold trust meetings, how to keep good records. And then so as one generation die off, the other generation just keep going with the same asset. It never really, like I say, in the public, it's still owned by the trust. But the private side of that trust is changing at generation after generation.
So I read somewhere yesterday, I don't know if it was in a book that you gave me or somewhere else that I read online, that a trust you could only really, a trust could only be active for about 25 years or something like that, and then it has to change or become a new trust.
Yeah, it don't necessarily become a new trust. You'll just have a meeting and renew it. It's something about public law, public that they want to see. They want to eliminate ambiguity. So if it's something that just says it's perpetual, sometimes it looks ambiguous. So they wanted to at least have an end to it. But it is not really the end. It's just really like a pivot point, you know, to say, okay, we're going to have a meeting, and in the meeting we're going to say we're going to go for another 25 years.
Okay. And so
it don't have to, it don't have to be over with.
Now, do the beneficiaries or the trustee have to change during that meeting, or it just has to be declared that we're going to renew it for another 25 years?
Yeah, it just be declared that you're going to renew it for another 25. You would just update the trust document. You never change the original trust document. You only make amendments to it. So you will have a meeting, and then you would make an amendment, and then that amendment would go in the trust book, like in a section. There'll be a section in your trust book called amendment, and it will say paragraph number 3 on page 4 says this. It was changed to this. We had a quorum, and there was a supermajority vote, and we agreed that the trust will change to this, that, and the other.
Okay. The trust book, does it have to be a physical book, or can it be all, you know, on Microsoft Word, you know what I mean, saved on a disk or a flash drive or something like that?
I would say both.
Okay.
Because you know, so that, you know, it don't get lost or eliminated because your hard drive went out, and then you would keep that trust book maybe even in a safe or whatnot.
Yeah. It's like an external in a safe.
Yeah. So I would do both. I would actually do both.
Okay.
Is there a particular kind of book that you need to buy, or is that something that you can make yourself?
Yeah, you can make it yourself. Just a binder, just a little binder with tabs on it.
Right. Okay. That's pretty simple.
Yeah, the whole thing is real simple. Just put yourself in the mind that you are the author of it. As long as within the trust you still follow certain principles of trust, then everything else you can get real creative with it.
Mm.
Now, what about international assets or international ownership? Let's say if a family purchases land in St. Lucia or Ghana, it has property there, would they still use a trust created in the United States to hold it?
Oh yeah, because in actuality, a private trust is considered foreign to the public. It's already considered a foreign entity. And, you know, foreign and international law is governed by the UCC, Uniform Commercial Code, which is, in fact, contract law also. So contracts rule all across the board. So they won't frown on it at all. You just have to, whatever that jurisdiction that land or property is in those areas, you got to find out what their law is to show forth ownership. Like say in Ghana, I don't know if they have quitclaim deeds or whatever in Ghana. So you find out what they use to see, you know, what you have to do to show that the name of the trust is the owner of the land in that jurisdiction.
Okay.
Anybody else?
Mm-hmm. That's it for me.
That's cool.
For now.
All right. Well, hey, I'm your brother.
This is valuable.
Yes, ma'am. That's why I wanted to share it, you know, because I took about 7-8 months, almost a year, and I just focused strictly on studying commerce. And this was the most valuable tool that I was taught in commerce. And in the training, and they don't give it no more. So it was good that I had a guy that me and a partner of mine, we went all the way to Albuquerque, New Mexico. We had to go for the first 2 months for the training, and it was something because the prerequisite was this metaphysical training called ontology. It was a branch of metaphysics called ontology, and they had us go through that before we even got into trust. And it was like a whole weekend that we were in this conference room from like 7 in the morning to sometimes 3 o'clock in the morning dealing with strictly metaphysics, because it was all about, ontology is about observing your ways of being and being present, being in the now.
Yeah.
Which was critical, very critical. And I'll give y'all for instance. It was called Living Authorship. And they asked us, if you got any habits, smoking, coffee, whatever your habits are, we want you to make a contract with yourself and us right now that you won't do it for the whole weekend. And so everybody gave their commitments and made their contracts, stood up. And then one guy, after he made his commitment, his contract, he stood back up and said, nah, I choose moderation. He was like, and he was already drunk. He was drunk then. And so, so the guy who was teaching the class was like, he said, why are you here? Why don't you just leave then? He's like, who would want this guy as their trustee or they trust?
Yeah.
So it started. It was something. It started immediately, the understanding of it, and it was like, wow, it was all about your way of being. And if you have taken on go ahead.
I imagine you have to, it's hard to, for us to see ourselves as the owners and the creators of our own constitutions, because we've been under, United States law, or in the Clear's case, UK law, for all our lives. So it's hard for us to understand that we have the power to do this without permission.
And this information,
That's right.
yeah, this
That's right.
information is so valuable, and we really appreciate it, brother, because it really is hard for us to see that, and you can clearly see how this guy Bernie Madoff used all of these different methods to where it was so difficult to find anything that he had, you know, because he knew all of these. He had, if he didn't know, he had a team that knew all these laws and statutes and stuff. Where you
You talking about Brandon?
Madoff.
Oh, Madoff. Yeah.
So, you know, this is information is very valuable. We really appreciate it.
Yeah,
Oh, man, it's all love, bro. Hey, this is what it's all about. This is what empowerment is all about. Is that we have a meeting of the minds, and we can share what was shared with us. You know, and that's, hey, I can't do nothing with all of it in and of all by myself without sharing some degree of it to spark others' minds to understand this powerful tool that we have. Really, it is the power to contract, the power to create contracts, and as Sister said, create our own law and our own constitution. Because I'm going to say this, when you have a trust, this is what they told us. They said you have a judicial side of the trust, an executive, and a legislative. Your judicial side of your trust is your trust protector. That if you want to add in a trust protector who makes sure that the trustee does what he's supposed to do and that the trust is operating according to the trust indenture, that's your judicial side of the trust. And so if you got issues inside of the trust privately, you can hold a hearing with the protector and petition the protector to adjudicate the matter that's at hand. And then you have an executive part of it, which is the trustee. Then you have a legislative side of it, which is the board of trustees. So it in fact is your government that you're creating, starting with your family. So imagine you got a husband, you got wives, you got children, and y'all set up this structure. It's a teaching tool to teach the children also how to be leaders, how to be governors, how to be managers, how to keep records. I mean, there's so much in it. It's your board of education. You could,
and it makes you organized because you have to have these meetings and you have to take notes, and you know, it adds another level to family management.
Oh yeah. That's
self-determination as well, right? You know, that you have got the power to move forward how you want to move forward. You don't have to follow the, you know, the typical route. You must go to school, you must get a job. You know, you can step out of that hamster's wheel and set your own trend and go your own way. I mean, I'm really happy that you shared this information with us today, because last week I actually started drawing up a contract. Well, I don't want to call it a polygamy contract, but you know, this kind of like guidelines for people who are going to join into that sort of bond, so that they know how to operate, they know what's expected of them, and also what they're going to receive out of joining into that circle of people. And it, in my mind, it's kind of it's similar to what you're explaining now, but I didn't realize that this was already out there. I didn't realize that there's actually legal framework for what I was thinking to exist. So you've given me a lot. You've given me a lot to work with. Because at first it was kind of seeming like I might have to get solicitors involved and you know, get accountants to check if it's legal and all the rest of it. But what you said is kind of confirmed that, you know, what I'm aiming for is more than possible.
Oh yeah, absolutely. Actually, the attorneys, I look at attorneys as incompetent. we always think we need attorneys, you know, but the attorney, he works for the state. He works for the bar association. Right. He said to milk that cow as much as he can, you know. And matter of fact, when you step into court with an attorney, they look at you as incompetent. That's why they don't talk to you. They talk to the attorney, because you needed him to
to interpret. He's the interpreter. A whole other language, and attorneys are trained. They're only trained to, you know, to negotiate the state statutes and codes. They're not,
Exactly.
trained outside of that.
Yeah, everything could be put in layman's terms, but, they consistently use this jargon and use this other language to confuse the public, It could be, could be layman's terms.
That's right, and it's not about equity. And the public, here's what we run into. I live in Ferguson in St. Louis, so I was out there doing the Michael Brown situation many nights. And when you try to get a court to do right and wrong, the court and the public is not about right and wrong. It's about form, procedure, and commerce. That's it. That's why you can lose a murder case. You can lose a murder case or win a murder case on a technicality because you didn't follow form and procedure. That shows you that it's not about equity. It's governed by maritime law, the law of the sea, not the law of the land. And that's the problem that our people have going into those situations, because they're trying to get a system to adhere to equity and right and wrong, and it's not built on equity and right and wrong.
Specifically, I saw a documentary about Ferguson that it dealt a little bit with the racial issues, but the rest of it was the quagmire of the court systems that they had. The people, when they developed the jurisdictions, I think after, I don't know if it was the anywhere from the 50s, 60s, 70s, I can't remember, but they started drawing up all of these different lines to keep everyone in the quagmire of owing one jurisdiction to the next one, right within that St. Louis area. And if you're not familiar with the court systems and how it works, then you're just going to be caught up.
Yeah, you're gonna get caught up real fast. We have to truly separate and begin to establish our own. Yeah. Otherwise, we're gonna keep experiencing, like when the anniversary of his death. I hate to say that it's an anniversary, but when a year later, people gathered back out in the same spot and they were playing the drums, and it was like, this ain't supposed to be a festive moment. It became like a festive kind of moment. And then, I see Mike Brown's father all the time. I run into him at the grocery store, and he just walks around with his head down because he didn't get no remedy. He didn't get no remedy. They went all the way to nothing. They went all the way to the Hague. They went all the way to the international court. Somebody told them that they should have went to the international court, wasted their time. They got there only to have the door slammed in their face, because nobody is really teaching how the system is broke down.
So you're saying that they actually went to the Hague?
They went to the international court. Yep, they did.
And still never got no justice.
Got nothing. Zero. But more protests. We have become professional protesters.
Yeah.
Please don't get me started on that.
Yeah, this system it wasn't meant for us to win. We got to stop trying to make it work for us. It wasn't designed like that. I wanted to ask another question too. Another question came to mind about the gold. It's illegal. Technically, it's illegal in this country to own gold. So how would you use that to back your own money in a trust?
Oh, no, it's not illegal to own it.
Okay.
No, it's not illegal to own it. As a matter of fact, I buy silver. I buy silver rounds down at a place called Missouri Coin here in St. Louis, and they like $21 an ounce. But you have two distinct forms of silver. You have generic silver and you have U.S. minted silver. The U.S. minted silver is considered legal tender, but the non-U.S. minted silver is called generic silver. But yeah, you can get it. We use it in our trust and stuff like that. And then gold, the gold aspect, you got something called carat bars and you got big gold. Like I buy big gold. Big gold is where they broke it down into grams. And big gold is where, like, I have an account online and I can buy a gram of gold, which is around $30 right now for a gram. And then I determine what vault I want them to store it in. There's one in New York, and there's one over in, I think, the UK, where you can have them stored in the vault. and you at any time, if you want them to send you the gold, they'll send it to you. Or they have a big gold prepaid debit card. You can once you got 1 gram of gold that you purchase, you can get the prepaid debit card. And at any time, you can redeem the gold in the vault into U.S. currency, and it'll go right onto your card.
Okay.
They have one in Philly, right? Because I think the Federal Reserve is in Philadelphia, right?
Yeah, but I'm not sure if the vaults that BitGo uses is in Philly. I know it's one in New York. When I log in, it showed me like what they are. But the carrot bars is the same way. Carrot bars, they sliced it down into grams, so you can easily buy gold, and it's like on these little credit cards. They put like a hologram on the back, and this gold has already went through the process to be classified as I think 0.999 gold, so you don't have to go get your own certifications or nothing for it. But it's a good way to invest in gold without having to buy ounces at a time if you can't afford an ounce. You can just keep accumulating the grams, and you can use them in your trust.
Okay.
But yeah, no, it's not illegal at all. They just took it off the gold standard, the U.S. dollar off the gold standard.
I thought they was confiscating people's gold at that time, though.
No, they were just putting an ad out. That's what the confusion was. They were putting out in the past 2 or 3 years, I think 5 years, putting mad ads out to buy gold. You know what I mean? So people, what it seemed to me was so people wouldn't have it any longer. And it seemed like they were trying to manipulate and monopolize it for a good amount of years. That's how I saw it. But it might have seemed like they were trying to make it was just commercials all over the place.
Yeah, now that I remember, when they took the U.S. currency off the gold standard, they actually asked people to turn in their gold in exchange for currency.
Yeah,
but it wasn't. They weren't making anybody. It wasn't asked.
That was making me nervous. I ain't gonna front.
Well, and check this out. When you go, guess what? When you go buy silver, like when I go to the location where I buy my ounces of silver, you can't use a credit card. They won't even let you use a credit card because those companies, they know that at some point in the future they may come and try to confiscate it again, and so they don't want to create no track record. So then they come after all the people who bought gold or whatnot. So you can't even use your credit card. You got to come in there with cash.
Oh wow.
And it's a hedge. And really, gold and silver, more than it is an investment, it's a hedge against inflation.
Right. I suppose you could probably also use Bitcoins to fund your trusts.
Right, yes. Yeah, you can get real creative. Big gold would be a very good one, too. I've been studying some big gold myself.
Okay.
Yeah, that'd be real nice. Once I build computers, and I fix computers, and I'm going to build me a big gold machine, a Bitcoin machine, where I can mine it. You just need a real good graphics card and maybe a quad-core processor that's just going to be strictly devoted to mining Bitcoin.
Okay.
So we all can get into some stuff, and like I say, I'm available to you all whenever, based on the little that I know. We all could put our heads together. I'm always into partnerships, creating partnerships. Like that second time when I went to Albuquerque, New Mexico, it was called Living Partnership. And it was a series of metaphysical exercises that we had to utilize to understand what partnership means. And since that training, I've been creating partnerships all over the place. They gave us an exercise where we had to go in the community and come up with enough food to feed 76 people without spending a dime of our money.
Oh, wow.
So we couldn't spend no money, and we had to be back by a certain time.
Yeah.
Go ahead.
Box clothes and everything.
So we went out in the community and came up with enough food to feed hundreds of people. We all went. It was a lot of us though, but we all went our separate ways, and we just went places and just asked people like to give in the name of love. It was a cold exercise. I mean, we went to like McDonald's was giving us. I know that's horrible to eat, but McDonald's was giving us extra value meals. Sweet Tomato, a place called Sweet Tomato, was giving us bags of soup. We went to a farm. They gave us bags of greens.
Oh, okay.
We went to the grocery store. They gave us like cases of water. I'm talking about for no money. It was just like because of the spirit that we came in, and we was in such a way of being, of giving and love that they gave to us.
Yeah.
And
yeah.
we that was how we ate that day.
Wow.
Mm-hmm.
Yeah, that's dope.
So, you know, so that it taught me a whole lot. So, you know, I'm in the spirit of giving. You know, I'm your brother, and anytime feel free to reach out to me. Anything I could help you with, help you understand based on what I know, and I'm willing, you know, to help with that.
Could you type your email address in the chat box, brother?
Yeah, definitely will.
Oh, yes, ma'am, absolutely.
PayPal address specifically.
You know what you were telling us about exchanges not being taxed? Is there limits on that? I mean, it kind of just reminds me of the Ubuntu system where, I mean, I do that a lot, especially if I'm low on cash. I'll do something for somebody in return for the thing that I want. But I don't know what it's like in the US. I'm not too sure in the UK. Hold on, you guys. 1 second. I'm coming. Is there any limit to how you can use that system?
You saying like to not pay a tax or what, or to avoid a tax? Remember, it's illegal to evade a tax, but it's not illegal to avoid a tax.
Okay, so it would be perfectly okay. Like if I said, if I was an accountant, say, if I say to somebody, I'll do 10 hours worth of accountancy fees if you every month if you fix my car for me or service my car for me every month.
That's an exchange. Yeah, that's an exchange. You're giving substance for substance. You hear me?
That's cool in the US. Sorry,
like bartering. Like bartering is not taxed, so there's no, you know, there's substance for substance. It's, you know, whatever value you give it, you know, you basically assigning your own value to something of substance in exchange for something that someone else has assigned a value to. You're just making what you all have agreed is a fair exchange. So there again, it's contracting.
Okay.
A contract is the agreement of the parties. The contract begins with the agreement. When you write a contract down, an express contract, they call it a memorialization of a contract. But the contract is really the agreement of the parties. But the writing down of it is called a memorial. You memorialize the contract.
Okay, that's something I need to look into then. I'm hoping to just sort of start a business doing that, so I'll look into it a bit more. Thank you.
Oh, you're welcome.
I need to go now. So once again, thank you very much. I feel like we're making history right now, just telling your information. Trust me, I think the minds that are in this webinar are going to share your information out there, and it's really going to make a huge impact to our community. And my main thing in my mind is that this kind of information is really going to take us out of poverty. Maybe not everybody, because, you know, like you were saying about the metaphysics, that business is all mental, and some people are just programmed to be broke, forever broke, and some people are really in their minds. But, you know, in a general, I think that this is really going to be a game changer for the Black community, and so thank you for sharing that with us.
Yeah, this is sovereignty.
Well,
this is what sovereignty really looks like.
Right. That's what that's right. Taking charge, becoming the author of your own reality. That's it. You know, you can't be free if you don't first understand how they got you a slave, and then you don't understand what kind of vehicles you can use to propel you into the next level of that freedom. I'm about to send. Yes.
All right, Carl, I've got your email address. Oh, hold on, you put up two there, right? Oh, your PayPal as well. Well, let me take that.
Yeah, I sent my PayPal email is there, and my information email. Because that PayPal email, I only use it for PayPal. I don't use it for anything else. But my other one is Navigation of Peace.
Oh, okay. Is Navigation of Peace the name of your company you use to teach the 6-month course about trust?
No, the name of the company I use to teach the trust is, I have actually two of them that work together. It's Creative Genius Technologies, as well as Invest With Us. Invest With Us LLC.
Okay. All right. Well, everybody, salam alaikum, shalom. I don't know. Peace. I'm being called. Thank you again, and bye, everybody.
All right, peace.
All right, you have a good one.
We'll be in touch.
All right,
Yeah,
peace.
please keep in touch. Bye.
Also, this whole entire webinar is being recorded, so you can go back for those who just came. I look like Sister Nanu just came on.
Do you need an email address for that? Let me put my email address. Oh, hold on.
Will you be emailing us the documents, brother?
Oh yeah, matter of fact, I tell you what, I'm gonna copy and paste the download link into this chat box so you can get it out.
Okay, thank you. Is it from Dropbox?
Yeah, it's gonna be on Dropbox.
Excellent.
1 second. Okay, there we go. All right, there's the link to download the books along with this webinar. I mean, well, the recording is not done yet. It has to convert. So once it converts, I'll let you all know. Make it available to you.
Okay.
Okay.
All right. Thank you again.
You're welcome. Feel free to reach out to me anytime. You got my email. Y'all know how to reach me on Facebook too.
Yeah.
Hey, thank you so much, brother. Really, really, really appreciate it.
Anytime, my brother.
All right. Peace and blessings.
Peace and blessings.
Peace. Yeah, that's great.
Yeah, well.